Dear students, so welcome back to Industrial Property, and that would be HOE 6065. So we're looking at patent law, and I've been exploring various options and the various issues that arise with regard to patenting of an invention. And I've spent quite a lot of time on that, and well, it's all good. So let's see, I plan to wrap up patents today, talk a bit about designs in very basic terms, and then I've already put up all the material in Moodle, what is for exam and what is not for the exam. And so hopefully everything should be crystal clear, and then we can already get ready for the exams starting from next week. Yeah. So, and of course, there's homework too as well. So keep that in mind. Don't forget that part. It's about compulsory licensing. Still have about 10 days to go. Of course, compulsory licensing has become a hot topic nowadays. I'll talk about that as well. So, we have gone through the entire gamut of how to invent something, and then what a sort of an invention is patentable and what is not, and what are the requirements and the key considerations, and of course the procedure and the key people at the patent office and in the whole process that has been outlined in the past. I also discussed very briefly about the national procedure, the regional procedures, the international procedure under the Patent Cooperation Treaty. And well, as a lawyer, I also worked as a patent attorney for a long time. And at one point in the law firm where I was working, we had almost, you could say, 3 to 4 patent applications a month, and that becomes quite substantial. You're talking about 40 patent applications in a year, and I was there for 9 years. Yeah, so this gets out of hand, and of course, the whole procedure in the patent office is also quite strict. You have to be very careful, especially with regard to deadlines, yeah, and other criteria. These have to be strictly fulfilled. So, what are the rights of a patentee? Well, let's presume you went through the whole process and got your patent. Then, of course, you get certain exclusive rights. And patents, just like IPR, are usually referred to as negative rights. You don't have to work the patent, but you can prevent others, third parties, for example, from misusing your patent rights without your consent. And this could include things like making, manufacturing, using, offering for sale, selling, or importing or exporting. So all of these things are covered over here, and it's outlined for product patents what is covered, and for process patents also what is covered. So of course, you can, as a patent holder, prevent others from commercially exploiting your patent unless they have a license from you. Now, this is a very voluntary procedure, and of course, you can set your uh, the money, and you can set your conditions. But in certain industries, this doesn't always work out. So, for example, in the mobile phone industry, computers industry, you have a lot of multiple patents and different companies and different proprietors, and so that's something you can see. For example, you have a Samsung phone and you have a Google software in it, and some elements may be patented, some may be copyrighted. So all of these result in a big mix of things, which is why you have different norms. And especially in the IT industry or ICT, information communication technology industry, you have these fair and reasonable terms. So that's friend, and that's something you can check out. These are specific terms for licensing: fair, reasonable, and non-discriminatory terms. So, of course, there are a lot of pressures that come up, but these are all still, nonetheless, we are talking about very voluntary procedures. Unlike unlike these other aspects, which would include compulsory licensing, and the homework also is about this process. So, what are the rights conferred by a patent? Well, you are the patent holder, and so you can prevent others from doing any of the things that I have outlined. And your rights are for 20 years from the date of filing the patent application. Now, of course, look at Nokia, for example. Initially, Nokia, for a very long time, was a market leader in the manufacturing of phones and mobile telephones. And they had a lot of patents, they still do have them. And ultimately, of course, Nokia sold its phone division to Microsoft, and there were other such transactions. And now Nokia is sitting on a pile of patents. So what Nokia does is research, development, innovation. That's number one. And they keep on adding more and more patents to their portfolio. And number two is they are what we call patent trolls. Now, this is not a negative thing. Basically, they have certain rights. Maybe they don't intend to use those rights for patented inventions, but they can always call up Microsoft or Google or whoever and say, hey, you are using certain technologies and we have the patent for that technology. So you should not use it unless you get a license from us. And our license fee will be 100 million euros. And if Microsoft says no, then patent trolls will simply say, okay, fine, we go to court and let the court decide, do we have a patent or not? And is the patent applicable or not? And are you infringing the patent or not? So this can often result in a lot of litigation. Now, you may think that this is a bad thing, but not really. Well, all litigation tends to be, it's a give and take situation. You have to do a cost benefit analysis. If I'm going to sue you and if I end up spending 10,000 euros and in return I get nothing or 5,000 euros, then that's a loss for me. So these are often economic constraints and reasonings which influence a lot of litigation decisions. And you may have followed in the past these patent wars between Apple and Samsung and vice versa. And as somebody once said, jokingly, that there was Nokia and then there was Apple. And Nokia made simple stuff, sold for simple prices, less prices, and Nokia sold simple stuff for less prices, and then Apple made high-end stuff, which was very expensive. And then in came Samsung. Samsung copied Apple's stuff and sold at Nokia's prices. So, of course, these can cause all sorts of problems and litigations. And these can have different results in different parts of the world. So if you look at the Apple versus Samsung legal disputes, there were a lot of problems that arose. And at one point, the Samsung legal head said that they have a legal budget of 20 billion, billion US dollars, 20 billion US dollars to fight Apple. But at the same time, it's interesting to note that Samsung is the biggest supplier of semiconductor chips and other technologies to Apple. So you see, there's a lot of this interlinking, but at the same time, there's a lot of fighting. And so these are all situations that arise. And of course, these are anyways within your rights as a patent holder. So you can prevent others from misusing your patent. There are also some case laws on this. So we'll talk about them in a few minutes. So when you look at compulsory licensing, now that you have done the homework, I hope you have understood compulsory licensing in more detail. And of course, wider public interest is the key. So for example, what would be a wider public interest? The coronavirus pandemic. Now, this is not the first pandemic to have hit in modern times. Before this, there was bird flu. Before bird flu, there was HIV, so in the 1980s, 1990s, 2000s. So these sort of things have been going on. And so there have been a lot of discussions about these sort of black swan events. They happen once in 100 years or whatever, but they can have a devastating impact on human civilization. And similarly with the coronavirus situation, It's no point in getting a vaccine if you're in Estonia or in Finland or in France or in the US. You still have to open up the borders, you still have to have free trade. Otherwise, you can't stay locked up inside in your countries forever. And what that would now mean is there are whole parts of Asia, Africa, South America, which are not, fully vaccinated. The people are not fully vaccinated, and so this is a problem area in which case, the only solution is to have a mass vaccination program. Now, of course, there are people who may not agree with vaccines. Yeah, I'm not talking about that right now. But the problem that arises is that Pfizer, Moderna of Johnson and Johnson, AstraZeneca, all of these are patented vaccines, and the drugs that are used for the treatment are also patented. So, well, if you have a compulsory license regime, what you're basically telling Pfizer is that they have to give the right to a company or a factory in some other country, and they will now manufacture and sell the vaccine for a lower price. Now, why would Pfizer want to do that? Pfizer would say, no, the price of this vaccine is 18 euros, 20 euros, and that's it, no negotiation. Yeah, well, things don't always work like that. And so you have a lot of debates about compulsory licensing. And there was the TRIPS agreement, then the Doha round. And hopefully, when you do your homework, I hope you have understood the essential aspects over here. And generally, this used to be a developed world, developing world, first world, third world problem. But now, recently, the United States has said that yes, they feel that there needs to be compulsory licensing in a very limited way for the coronavirus pandemic. And essential drugs are required in the wider public interest. So again, you see a lot of changes taking place. So, what do you do regarding a patent? So you have a patent, you don't just frame it and put it on the wall, you need to take action on it. And so these are known as infringement proceedings. And for this, you have to go to a court and you have to determine what constitutes infringement. So let's say I have a patent on this product. Yeah, let's presume it's a brand new product, it's novel, it's innovative, it has industrial applicability. And so, well, I have the patent in Estonia, Finland, Sweden, Germany, France, UK, Netherlands. Yeah, let's presume. So now if any ship comes with these products which have been manufactured in China or India or somewhere, and if any such ship enters European Union waters and then comes to, let's say, Tallinn or Helsinki or Hamburg or wherever, then in that case, or Rotterdam, then in that case, of course, you have a patent, and so you can sue the importer. Yes, you can sue the manufacturer in a foreign country, and you can do all of these things and get these products seized by the court. And because they are infringing products, they are exactly similar to what your patented invention is all about. But this doesn't always get resolved so easily. You have to, of course, make sure that third parties make direct use of the invention. And if they are not directly using it, then it can be a big problem. So there's this patent case law, and the case law is the Monsanto case. And it's very interesting because this company had patents for soya crop products, and these patents were in the European Union countries, in the US, but not in Argentina or Brazil and some other South American countries. So this product was grown in, let's say, Argentina, for example, and now it's not illegal because there's no patent. And so Monsanto can't stop the farmer from growing the soya bean product in Argentina. Now, this soya product was grown and then cultivated, and then it was processed and turned into a different product. So soya was, of course, the raw material, and now the finished product is something else. It's like you take milk and then you turn milk into yogurt. Yeah, so these can be sometimes a bit different, or into, I don't know, milk white chocolates or something, or whatever. So you don't have the same product anymore for which the patent was granted. And when this product was then exported to the European Union countries, so Monsanto took action in Europe, and the case that came up was, would this be infringement? Because this is not the product that is coming to Europe. It's a completely different product. This was just a raw material for that other bigger product. And so again, these are the sort of complications that can arise. Another issue that came up was there was a drug to treat HIV and AIDS, yeah, and so there was a patent in European Union countries, but not in India and not in Brazil. Yeah. So the Brazilian government requested the Indian company to manufacture the product in India. And this is reverse cycling, it's reverse engineering, it's not complicated. This is the main product. It's like, wow, but once you open it up, you can see that it's nothing special. It's just, basically a pen. It's got a spring, it's got a refill, it's got this mechanism for whatever. And so based on this, reverse engineering is not rocket science. And because this is an essential drug, there was no patent for it in India or in Brazil. So the Indian company made millions of these capsules, packed them, packaged them, and put them in the containers, and they were sent by ship to Brazil. But this ship didn't go from India to Brazil via South Africa, as you would have expected it to. But because of the way supply chains work, the ship went via Suez Canal to Europe and came to Rotterdam. And the plan was then the container from there would be shifted to another ship, which would then be going to South America. So of course, when the product came to Rotterdam, then the company filed patent infringement proceedings. And so now again, the question that comes up here is, like in the airport, you are in a transit zone, and in many cases you don't need a visa. Yes, so of course this can be quite complicated. So let's say I want to go to Kazakhstan, so I go via Moscow, for example. Then in that case, I'm in a transit zone, then hopefully I don't think I need a visa. I mean, I don't think so. On the other hand, let's say if you're going from Helsinki to Buenos Aires, you have to go via maybe Florida, Miami airport, maybe, I don't know. So in all of these situations, you have this transit area, and that's the same even for harbors and shipping companies. So the question was that, did this product, the drug, enter European Union soil, as in territorial soil, national soil, or was it just in transit? So you see, there are all these legal issues that can be very interesting, but can also cause a lot of problems. So what are the defenses available? Well, it's not within the patent. So let's say you have a patent for this, but I make a product which is different. Yeah, I make a product which is like this. So this is a mouse which can be used for drawing. So it's got a software application to it. So of course these two are not the same, although you may think that they can both fit in the pocket. And this is also a pen, this is also a pen, but this is a sort of a physical pen, and this is more of a software object. It's more like a mouse. So again, you have an issue here. The same question that comes up is, this mouse and this mouse, are they the same? So of course, a lot of problems that can arise. Sorry, I'm here today. My laptop burned down, and so I'm using my wife's computer. Until I get a new laptop. All right. So what is not an infringing act? Maybe acts done privately and for non-commercial purposes. So you do something in a laboratory or at home, or acts done for experimental purposes, for non-commercial reasons. These are all issues. Then of course, if the patent is invalid or the patent has expired. And so these are the brief outlines, and of course Litigation would be similar to how I described the trademark litigation. Yeah. So it can be very interesting, but at the same time, yeah, it can cause all sorts of technical issues. In such litigation, the best thing to do is, of course, to have legal expertise, but also you need to have the scientists, the RDI experts, the chemist, the physicist, or whoever, because in a court of law, really, it's not easy for me to explain the difference between this and this. So I will need to bring in uh, expert witnesses who can tell what are the exact differences. And this has to be in a technical sense. So of course, all of these are important issues. So maybe I have a patent for this mechanism, and maybe something similar could be used to turn this on or off. So again, there are a lot of these issues, and if your patent claims are too wide, then you can try your luck. But very often, this can result in a lot of hair picking and nitpicking, and it can get very crazy sometimes. So we have looked at different issues about patents and the pluses and the minuses. Of course, it's not a guarantee that a patent will help you to commercialize in 100%. That's never so. What you often have is a scenario where companies apply for multiple patents, and they sort of create this protection and sort of a barrier which can cause a lot of problems for newcomers or competitors. So that's all a part of the game, and of course there's a lot of economics that goes into these things. Now, in the patent lecture notes, I've put up some aspects. The notes are there, and patent convention. Again, you don't have to know all of it. There is the guideline, the office guidelines, but just see part G on patentability. Yeah, that's all that's needed. Then there are patent case laws that you need to know. Then there are some other things. There's this WIPO, World Intellectual Property Organization Patent Drafting Manual. It's not for the exam, just for you to know. Then there's a case study of the toy ball and the double pipe. These are more popular in my what would they be, autumn classes, because then I have a mixed course with engineering and law students. And of course, engineering students love this whole idea of understanding how to draft claims. Now, as lawyers, chances are that you will not go into this area at all. To become a patent attorney, of course, you need to have a science background plus a law background, and that's not something that everybody does. Well, not everybody is crazy like me. Yeah, I did my BSc in chemistry, and then my LLB in law, then my Master of Arts in law, then this PhD thing. This thing is crazy stuff. Yeah, all different aspects, but somehow they all get interlinked with intellectual property rights, and so these are all aspects that it's still going on, never ending. But if you look at the case study of the toy ball and the double pipe, you sort of get an idea of how the claims have to be drafted from a legal viewpoint. If your claim is too narrow, then you get stuck. If it's too wide, then you get stuck. If you call your invention a toy ball, you're limiting it to a toy ball, which means your competitor or anybody else can make a toy oval, and then you're in trouble. So rather, you could call it an amusement device, yeah, which is not a toy, but it's an amusement device. So it's not just for children, but even for grown-ups. And so there are all these issues that come up. Similarly with the double pipe, because it has a lot of implications in technology sector. It helps to control overheating, and that's a very important aspect, which plays a big role. The enemy of the IT industry is overheating. Your computers, your servers, if they get overheated, you're in trouble. Which is why in Finland, south of Finland, you have this Google, uh, facility in this underground bunker next to the sea, and so you have the sea water which cools down, and all of these things are relevant, and so a double pipe comes in that category. And these case studies are interesting because they talk about how the whole process develops. So the inventor and the patent attorney discuss, they come up with some claims, then the patent attorney checks online, everything is available online, espace.net, USPTO website. They all have millions, millions and millions of documents, and you can do a search, and it's quite technical, but it's quite possible to do all these things. And so the inventor and the patent attorney think that they now have an idea about what is prior art and what has been done and what has not been done. And then, of course, they apply, and then it turns out that the patent office comes up with something that may be similar. And so now you have to work around this objection and try to overcome it. And you can do that by deleting some parts. Of course, you can't add anything extra, generally speaking. So it gets quite complicated and technical, but it's doable. All right. So that's patent law. Patent law is over. Remember, industrial property is 3 credits. Yeah, so there's not much to be done here. You have patents and then you have trademarks. So we have spent a lot of time on these things. And so if you look at the syllabus, for example, here we have, just looking at this, sorry, it's very uncomfortable. Yeah, but if you can bear with me. So here is your industrial property syllabus. So it's 3 credits, and we have dealt with all sorts of issues here. Now, what's left out? 3 more things: designs law, geographical indications, and trade secrets. Now, well, it's good to know all these things, and I've had some discussions in the past with academics from other universities and other countries, and even some of my own students have complained or referred to the fact that in University of Helsinki they don't learn all this stuff at the bachelor level. It's more for master's level, but it's good to know all these things. So since this is an open book exam, you should have an idea about some of these issues as well. Designs law is something we'll talk a bit about today. It's for the exam. Again, very simple, very basic. But geographical indications and trade secrets are not for the exam. However, they have certain regulations and directives which I would like to draw your attention to. These are good to know so that at least you have an idea about all of these issues. Geographical indications basically are a scenario where, not so much in Finland or Estonia, I suppose, but more in Italy, Greece, France, Spain, and other countries, you have this specific provision for products that are manufactured, agricultural products or spirits or drinks or whatever, which are from that geographical area. So champagne comes from that part of France. Cognac comes from that part of France. Scotch whiskey comes from that part of Scotland. Yeah. So all of these are, of course, very relevant issues. And those of you who drink would know that all cognacs are brandies, but all brandies are not cognacs, in a very simple way. So again, there are these regulations for this, and this used to be covered earlier under trademarks, and then you had community trademarks and all of these wider trademarks, and they sort of didn't really click very much. So now you have geographical indications. Of course, not all countries in the world see it this way. So for example, in the US, there's a lot of dispute all the time because this particular cheese comes from Greece or from Turkey, and then everybody starts fighting, and they are like, this cheese is from this part of Italy and from this part of Greece and nowhere else. And then the Americans are like, come on, cheese is cheese, it comes from a goat or from a cow, and that's it. So of course, there's a lot of these problems in the world. And so a lot of the free trade agreements that the European Union enters into with various countries, including now with, for example, the UK, they have sort of emphasized also on these aspects. Then trade secrets are a simple scenario where you don't want a trademark, you don't want a patent, you don't want a design because you have to disclose. So instead you go in for a trade secret. So Google has its algorithms, and these are trade secrets. Algorithms change maybe every month, maybe every week. There's no point in getting a patent for them. You could if you wanted to, if there's a technical effect, but otherwise, why bother? So you just try to keep it secret. It's like Coca-Cola. It's colored, sugared water. So there is one factory which makes the color. There's a second factory which makes the sugar. There's a third factory which makes the water. And there's a fourth factory which mixes all the three ingredients. And of course, if you have 0-calorie Coke, that's even worse because now it's only colored water without even sugar. So of course, you see, this is a trade secret, and the whole idea here is that factory A, factory B, factory C, the people don't know each other. There is no get together. There is no Christmas party. You work on a need to know basis, and you don't need to know everything. So very few people on the top know everything. Everybody else just has their own limited vision, and they work within that. So of course, this is how a trade secret works. But a trade secret is only effective as long as it is a secret. When the secret is out, then it's gone. So there have been some regulations and laws in the EU and the US to deal with this issue. So you're supposed to file a a confidentiality agreement, a non-disclosure agreement. There could be fines in some countries. There could be imprisonment and terms like that. So the whole idea is to try to preserve and protect data somehow. But again, this can be quite problematic, especially when you have to prove that you are the owner of a trade secret and somebody else is using it or misusing it. So the best thing to do is, of course, to keep it a secret. But what we will talk about are the EU designs regulations, and so these are very essential aspects. Now you see, all of this and this, some aspects of this are of course technical and functional in approach, but some are just about the looks. It has to be fancy looking. Why? Well, why not? So of course you see that everywhere. You're covered with designs, and designs come in every package and all sorts of things. The whole idea is to sell something, and there are so many similar products in the market, so you have to try to come out with something different looking. It is something which appeals to the eye. That's it. It has no functional aspect. If it was functional, it would be affected by patent law. It's not functional. It's just all about the looks part. And so when we look at this issue, then there's a designs law regulation in the European Union. So you can have registered designs and unregistered designs. And of course, there are some videos also about these things that are up there. Again, very basic and simple. I would love to talk more about this, but 3 credits. Let's keep it simple. So if you were to look at the designs regulation, Article 3 talks about the design, and it deals mainly with the appearance. So that's the key part over here. And requirement under Article 4 for protection is if it is new and has individual character. And of course, it has to, in this context, be visible. So what happens is, if it is a component, let's say it is a car engine. The problem here is the car engine is covered by the hood of the car. So then it may not have design protection. Compare that with, let's say, the engine of a motorcycle, and maybe that is a bit more exposed. I'm not talking about the functionality part, I'm talking about the looks part. And in that case, you say visibility becomes a key factor. So what is novelty? If no identical design or new design has been made available to the public, and there are certain dates for that. Now, of course, the biggest issue with designs law is sort of the Cinderella of IP laws, is that you can get a design registration quite easily, and that's also a bit sad because it sort of gives it lesser value somehow. And if you can get it easily, you can lose it also easily. So what is individual character under Article 6? Overall impression it produces on the informed user. So again, very basic legal aspects. Disclosure under Article 7. Of course, If it's been published, exhibited, used in trade or otherwise disclosed, then it is not new, it has been disclosed. Although there is a provision for confidentiality agreements, so that's interesting to see under Article 7. Article 8 is purely about the technical function. If it has a technical function, it is not registrable as a design. One simple example of this was, contact lens. Yeah, so you put the contact lens on your eye. Now the problem here is the design of the contact lens has to be like this, curved, because that's how it would fit on your eye, right? So it cannot be some other shape because that would not sit on your eye. So what we are looking at is must match, must fit. And this is a very key principle which basically says that if it has a technical function or interconnections, then it is not registrable as a design, because then it becomes something which is patentable. So you have to get a patent for it. And then of course Article 9, designs contrary to public policy or morality. So these are all covered over here, and these are designs. And well, I won't ask much about it in the exam, but it's an open book exam, so you should know some of these basics about designs. There are some litigations in this regard, and designs can be a very interesting subject. But at the end of all of this, what I want to impress upon you is that, you see, patent is for 20 years from date of application. Yes. A design is unregistered is 5 years, registered could be up to 25 years, again limited. And then of course you have a trademark, which is after every 10 years renewable, so it is basically for life, forever. So now comes the issue. When Apple got its phone shape registered as a trademark, everybody thought it was funny, right? Ha ha ha, how stupid is Apple? But then Apple started saying, sorry, this three-dimensional shape is our trademark, so now you cannot make a mobile phone in this shape. And then Samsung, Nokia, everybody was like, what the hell, how do you make a phone that's round or something? I mean, how would it fit in the pocket or wherever? So of course, this shape is not trademarkable. It should have been at the most a design, at the most, if at all. But nothing else. But you see, this is where all the intermingling and the gray zone comes in. And this is what makes IP law very interesting, because you're trying to sort of get into different ways of dealing with issues. Designs law also has this sort of overlap with copyright law, but because we are not dealing with copyright law in this course, industrial designs are all about, industrial property is all about trademarks, patents, industrial designs, geographical indications, trade secrets. Copyrights are a different element altogether. Industrial property plus copyright is equal to IP law, intellectual property law. Yeah, so you see, these are all important nuances to keep in mind. So that's it, all done. We have looked at the various issues over here, and considered all the elements of property, industrial property, and seen all the issues that come up over here. I will put in Moodle all the requirements for the exam and everything. So this is it, last lecture from me, the end of the lectures, and see you soon for the exams now. So best of luck. And of course, if you have any questions, please do not hesitate to contact me, and I'll be happy to help you. So until then, goodbye.